Yes, sure. The tariffs are a tax, and that's a core power of Congress. But they're a foreign-facing tax, right? And that foreign affairs is a core power of the executive. And I don't think you can dismiss the consequences. I mean, we didn't stay this case, and one thing is quite clear is that the foreign-facing tariffs have in several situations.
Right, and we are.
I'm sorry.
Oh, sorry. I'm sorry.
Were quite effective in achieving a particular objective. So I don't think you can just separate it when you say, well, this is a tax to Congress's power. It implicates very directly the president's foreign affairs power.
Yeah. Mr. Chief Justice, we don't disagree with a large part of that. We think instead of thinking about foreign versus domestic, the better way of thinking about it is Article 1 versus Article 2. And as my friend finally conceded to Justice Gorsuch, there is no Article 2 power here, at least when we're talking about peacetime.
Well, you don't agree with a large part. What's the little part that you do disagree
with?
So
we agree with the idea that tariffs have foreign policy implications. Absolutely. Our founders recognize that. That's in the Federalist Papers. But nonetheless, they exclusively committed that power to the Congress in Article 1, Section 8, and gave it as its first power. So when you hear my friends cite cases like Egan and Garamendi, they just don't apply to this specific, unique situation in which Congress is given that power. And if you were tempted by this, I think the best place to look is Youngstown, because what Justice Jackson said, and I was surprised that he quoted pages 652, because what Justice Jackson said is, quote, emergency powers tend to kindle emergencies, so it's essential the public may know the extent and limitations of the powers that can be asserted, and persons affected may be informed from the statute of its rights and duties. And Justice Jackson went on to say there that it's notable our founders didn't give the president revenue-raising power even in a time of war.
Can I just get a clarification of your answer, which is you agree if the word tariff were in the statute, that would be acceptable and constitutionally permissible, correct?
No, it'd be constitutionally permissible. The question would then be, is the open-ended assertion of power here? Because every other tariff
I
statute
get as applied to this case, but the general point is, yes, Congress, you said it's assigned to Congress, but Congress can grant authority to presidents to impose tariffs.
Absolutely.
As a general proposition.
Absolutely.
Okay, so we have to figure out then what regulate importation means. And you've heard my questions. If this statute came out of nowhere in 1977, I think your case would be, obviously stronger. We have to figure out, at least I want to figure out what the Nixon precedent stands for and what Algonquin stands for. On the Nixon precedent, the question is, I think, was Congress aware of that, meaning that when they used regulated importation and it's now being used to encompass tariffs, that's not unheralded because Congress was well aware. President Nixon announced those tariffs in a nationwide primetime speech, 10% across the board in August 1971. It was not some kind of little piece of paper. So it was well known. The question then is, was Congress, why didn't they change the language? Why didn't they say regulate but not tariffs? That's kind of the difficult question from the Nixon precedent that I'll give you an opportunity to answer.
Thank you, Justice Kavanaugh. So 5 answers on the Nixon precedent. First, there is no evidence that Congress thought it was ratifying Yoshida. It was a single court of appeals case.
It's not somewhat my question. I never mentioned Yoshida. It's the use by the president of that power under regulated importation.
Oh, if we're just talking about that, President Nixon did not rely on the statute whatsoever. I mean, that's very clear. In fact, we have a Marshall McLuhan moment here because you have before you Alan Wolf, the person who was there in the room with Nixon, saying Nixon totally disagreed that this statute applied. So if we're just talking about Nixon, I don't think it can get the government where it wants to go.
Go to your other four. Other four.
So I think the only way it does any work is if the president is through the vehicle of Yoshida, and that's what I take it the government is arguing. And with respect to that, this cert-denied intermediate court of appeals decision, I don't think can come close to overcoming the clear, plain text. The word regulate words regulate importation. The word regulate has never been used. The Congress uses the term 1,499 times. We got about that number of hits when we looked at it, and maybe there's some double counting, but it is never used even once to impose taxes or revenue raising. And that was the question that Justice Barrett was asking. And so I don't think that this Intermediate Court of Appeals decision will get you there. And then even if you thought that Congress knew about Yoshida, and even if you thought they liked it, which there's absolutely zero evidence of, I don't think that helps the government for reasons that Justice Alito was pointing to, because Yoshida said three things. A, TWIA doesn't give the unlimited authority that the government is seeking here. B, they were only upholding the limited specific assertion of authority that President Nixon sought there. And third, going forward, the solution, they said in footnote 33, was to use Section 122 of the 1974 Trade Act, 15%, 150 days. So we have no problem with the president doing that. It's just that this president has torn up the entire tariff architecture. You know, for example, he's tariffing Switzerland, one of our allies, which we have a trade surplus, 39%. That is just not something that any president has ever had the power to do in our history. And the idea that Congress, by implication, did this in 1977 and handed him all this power, I think is really difficult.
Just ask the other. Go ahead.